Hello everybody, this is Daisy Plarda, and this is my Week 3 Discussion 2 post on the Sixth Amendment. There are two amendments that give an individual the right to counsel. The Fifth and Sixth Amendments are much alike, but activate at different times. Most people are familiar with their Miranda rights and how they have the ability to remain silent to talk to a lawyer, but this is the Fifth Amendment. With the goal being to explain the Sixth Amendment, it will be learned that this amendment activates at a different time. When an individual is facing imprisonment and being charged with a crime, they are entitled to counsel under the Sixth Amendment. Now, what is the Sixth Amendment? The Sixth Amendment guarantees the rights of criminal defendants, including the right to a public trial without unnecessary delay, the right to a lawyer, the right to an impartial jury, and the right to know who your accusers are and the nature of the charges and evidence against you. The Sixth Amendment is commonly confused with the Fifth Amendment, as this amendment guarantees counsel to an individual who is facing criminal charges. The Fifth Amendment is different. Under the Fifth Amendment, a person must be given Miranda warnings, including informing the suspect of their right to an attorney before a custodial interrogation by a government agent. It's easier to remember that the Fifth and Sixth Amendments work hand in hand most of the time, and that's why they are usually thought of as the same. The Fifth Amendment is for the right to counsel when being questioned in custody, and the Sixth Amendment is for the right to counsel when being charged. To have the assistance of counsel for his defense is a given right according to the Sixth Amendment and means a member has a right to be represented in court and given counsel when being charged. Sixth Amendment requirements. For any person who faces an imprisonment charge, it doesn't apply until criminal proceedings have begun. It's initiated through formal charge, preliminary hearing, information, indictment, or arraignment, and it applies to all critical stages in a criminal proceeding. The Sixth Amendment has requirements in order for it to be activated, and those are those requirements. Under federal and New Mexico law, any person appearing in court for an offense that has a possible sentence of imprisonment is entitled to an attorney. The Sixth Amendment is for anyone who is facing criminal proceedings. For example, if I got arrested and was being charged with murder, I then have a right to counsel under the Sixth Amendment. My right to counsel will stay with me throughout the trial and sometimes, but although it's not common, beyond that. Counsel for custodial interrogation. When in custody for solely questioning purposes by a government representative, the individual is required to be read their Miranda rights, which offers the right to counsel. Being questioned does not necessarily mean the individual is being charged with any crime, but they still have a right to not speak and seek counsel. However, it is not the Sixth Amendment that provides this opportunity. It is the Fifth Amendment that does. The Fifth Amendment right to counsel was recognized as part of Miranda versus Arizona and refers to the right of counsel during a custodial interrogation. It is required of an officer to read Miranda rights to any person who is being questioned or detained for any reason. The Miranda rights activate the Fifth Amendment, which gives the right to remain silent until counsel is present to offer guidance. This prevents the member from giving any self-incriminating evidence that can be used against them in court. Counsel for trial. When being formally charged and facing imprisonment, the individual has a right to seek counsel under the Sixth Amendment. This does not relate to Miranda rights and the custodial interrogation and is commonly confused because it relates. While the Fifth Amendment right to counsel may apply before a person has been arrested, the Sixth Amendment right to counsel does not attach until after criminal proceedings have begun against an individual. In the event that someone has been detained and is being charged with a criminal offense, the Sixth Amendment is then activated and gives the individual a right to attain counsel throughout any criminal proceedings thereafter, unless this is waived. Usually the Fifth Amendment is in place first, and the Sixth Amendment activates later. The person must be being charged with a criminal offense. The remedy for violation of the Sixth Amendment rule is exclusion from evidence of statements so obtained. If it is known that the right to counsel was not given when required, all evidence that was accrued in those investigative interrogations will be obsolete and will not be able to be used anymore. If it was the sole piece of evidence that was being used to convict an individual, they will no longer be charged under that specific statement. Any information gathered from an individual being charged with a crime is admissible when not given the right to seek counsel before speaking. This applies for both Fifth and Sixth Amendment rights because they both have to do with the individual having the right to counsel before questioning or any criminal proceeding against them. If someone has not read their rights, they are subject to incriminating themselves by providing information. However, if someone is in prison, they are not considered to be in custody in relation to this questioning. Therefore, they could be asked questions, given there are still limitations on what questions can and cannot be asked without counsel. So, it could be seen as a loophole if you really think about that. Conclusion. As the Fifth and Sixth Amendments work hand in hand to provide counsel to individuals, it is activated at different times. The Fifth Amendment provides the right to seek counsel under the Miranda rights during an interrogation while in custody. The Sixth Amendment provides the right to counsel when being charged and facing imprisonment. However, if this right to counsel is not given in both cases, the information that was obtained during that time will be obsolete and cannot be used against the individual in court. This can, in some cases, drop charges against the person in question. And those are my references. Thank you so much for looking at my post. I'm very sorry that I stutter sometimes, but I would be here all day if I kept trying to record it over and over and over. So please don't hate on me. Thank you so much for watching. If you have questions, please post them below, and I will try to answer them to the best of my ability. I look forward to seeing everybody else's posts, and have a good day.